Good afternoon. This is Eric, and I'm going to discuss the California labor and wage laws for Management 358 Practicum. I'm going to go over an introduction, a background. We'll discuss a little bit about the Fair Labor Standards Act, California, and their relationship to the FLSA, some predominant California wage and labor laws. Then I'll move on and discuss some current issues that are going on in California, as well as discuss what's coming on the horizon, and then I will summarize. So, as you know, being from California, we tend to be a little bit unique or different than the rest of the United States. So, it should be no surprise that California's wage and labor laws are diverse and a little bit different than the rest of America. Now, depending on where you work or your location, you could be paid at different rates, and there's no set standard as there is like a national wage, a national minimum wage. Different cities can impose their minimum wage, and it might be different than other cities, but what can't happen is it can't fall below the minimum wage, the federal minimum wage. You'll also find out that not all jobs are created equal, that depending on your career field or the path that you chose, you might be paid at different rates, as in regards to overtime or compensation or commission. It really just depends on what your profession is and what the standard has been set up in California, also known as the wages that apply to those particular jobs. So, being that California does have a lot of information, a lot of diversity in their wage and labor laws, it'll be really difficult to cover every single item. So, I hope to touch bases on as much of the information as I possibly can, or at least give a foundation so you could further research additional information if you needed to. So, with that, where do we start? So in 1938 is where I have chosen to start. The FLSA, or the Federal Labor Standards Act, was established in 1938 by President Roosevelt. Now you would think that a standardized wage and a standardized work week would be something that most of Americans wanted after living in the Depression and working for pennies on the dollar or 80 hours a week with very little compensation. But on the flip side of that, a lot of people were resistant. A lot of businesses obviously were resistant to this type of change because now they would have to pay a higher wage than they currently were, or basically they couldn't have anybody in slavitude anymore because now they had to pay a standard wage. So they felt this will hurt business, it'll stymie growth, it'll be bad for the economy. But President Roosevelt, he was adamant that this is what the nation needed, so he continued his fight to try to make this happen. And he did meet a lot of resistance, to include some big hitters that were against this, like the Supreme Court, shot down a lot of the legislation that he was trying to do. And eventually, through many concessions and amendments, 72 of them, it was finally passed on October 24th, 1938, and the Fair Labor Standards Act became the law of the land. So now what this did when they established it is it regulated child labor. It set the minimum wage, which shockingly at the time was 25 cents. So depending on your age, when you're looking at this or listening to it, 25 cents doesn't sound like a lot of money, but during a time where people got very little money, if any, to work and provide for their family, 25 cents was a big deal. It also set the maximum work week and standards for overtime pay. So the work week was set that it couldn't exceed 44 hours in a work week. So as you can imagine, businesses probably were in a little bit of an uproar, used to having employees working 80, 100 hours a week. For less than 25 cents. So this was definitely going to regulate how they did business. But for the workers, it was a win. Finally, they were getting a standard or a baseline to what they should get paid and how many hours in a week that they should work before being compensated even more for that time that they're spending away from home providing for their families. Additionally, it required record keeping. So now you had to have some books to justify who was getting paid, what they were getting paid. So basically, it added some teeth. So businesses, you always hear cook the books or a double set of books, which I'm sure still exists today. But this started to lend some transparency to what businesses were doing. Um, now, fast forwarding to today, the Fair Labor Standard Act today does still set and establishes the minimum wage. They also establish overtime. And it's currently administered by the U.S. Department of Labor, the Wage and Hour Division. Now, the Fair Labor Standards Act, they also still require record keeping, but some things that are a little bit different is they had youth employment standards affected employees, and this not only applied to the federal government, but it applied to state, local governments, as well as the private sector. So it's an overarching across-the-board standard of how we treat wages and labor in this country. It covered non-exempt workers to ensure that they're entitled to a minimum wage, which is currently at $7.25, which became effective in 2009. It set that overtime pay rate that it can't be less than one and a half times the regular rate of pay, or you hear time and a half. So that way, anything that you work, past your 40 hours, you're going to be compensated at time and a half for those hours. And it set the work week to 40 hours, whereas I mentioned in 1938, it set it to 44. This reduced it to a 40-hour work week. And again, as I mentioned, it's administered by the Department of Labor. Now, being in California doesn't just abide by the normal flow of the nation from what I've seen. I've been in California 11 years, and from the day I got here to today, it's definitely eye-opening at how far forward California tends to think in regards to employees. And I think they're predominantly known as an employee-friendly state here in California, that they do have the best interests of workers at the forefront of their mind. Now, in relationship to California, it's always sunnier in California. Just a little historical fact, or fun fact, if you will. In 1920, California was already paying higher than the minimum wage that was established in 1938. So they were paying 33 cents an hour. So again, why it doesn't sound like a whopping 25 cents, it was actually higher than that, 25 cents, and it was higher 18 years earlier. So as you can see, this whole big struggle across the United States just to get a standard wage, California was already setting that bar that, hey, we're going to pay workers 33 cents an hour, and we did it 18 years earlier. So it should be no shock today that California, again, is trying to increase the minimum wage and to stay ahead of the feds in regards to taking care of employees in this state. Currently in California, the minimum wage is at $10 an hour. And as I mentioned before, the federal minimum wage is $7.25. Now, with that $10 an hour, you do have a higher cost of living in California versus other states. Whether that's attributed to the $10 an hour or the constant being ahead of the federal minimum wage would be more for an economist to discuss than someone such as myself. But it is important to note that California, again, is higher than the federal minimum wage, and therefore get to maintain their status as an employee-friendly state. Now, as I mentioned in the first slide with the introduction, that location, wages do vary based on your location. If you work in LA, San Jose, some other cities in California, believe there's a total of 6, you are paid higher than the $10 an hour minimum wage. California minimum wage, that is. So your location does have a factor, but one thing remains true is that at no time will the minimum wage in those other cities dip below the California standard, just as the California standard at no time will dip below the federal standard. So there is a hierarchy or a trickle down of what you can't go below, but you're more than welcome to pay your employees whatever you want as long as you exceed the standard or at least meet the standard. Um, as with the federal law, overtime for non-exempt employees is paid at 1.5 times the regular rate. Um, Something little unique is vacation time that's earned by employees through their employer has to be paid out to the employee upon them leaving. So there's no use it or lose it pay system in California for in regards to vacation. If you earn it, you get it one way or another, whether you use it or you're paid out for it. Which I found interesting because I work in California, but I work for the federal government, and we are on a use it or lose it system. We're capped at a certain amount of hours, and if we go over those hours and don't use them, we lose them. Something else that's important to note is the predominant wage and labor laws also discuss meal and rest periods. That's important because a lot of companies they just think, well, I'm paying you for 8 hours. You're going to work 8 hours. You go take a 15-minute lunch, eat at your desk, whatever those case might be. But California said, hey, that's not fair, and there is a standard to what you can offer as far as meal and rest periods. And basically, for every 5 hours that you work, you're entitled to a 30-minute uninterrupted meal period. So I do think that's important because a lot of employers, now some professions obviously they take their lunch while they're at their desk because they're professionals or they're not non-exempt employees. So it's a little bit different for certain professions, but for the majority of workers, you get 5 hours of work, you get a 30-minute uninterrupted lunch period. I've dealt with this personally because I used to work for a hospital that was ran by the federal government, but had vendors who employed contractors, but the contractors resided in California, and a lot of the time, these weren't exempt employees, and they kept saying, well, they can have a working lunch, and we're going to have a meeting during their lunch break, and it was something that we constantly had to remind them that uninterrupted meant exactly that they're allowed to leave their place of employment, that they're free to do what they want during their 30 minutes, and if the sections or the supervisors prevented that, then they would be compensated for that time. And so if an employee chooses no break, then it's paid at the regular rate, which counts against that 8-hour day. So sometimes employees will allow you to skip your lunch, so you can go home a little bit early or come in a little bit later. But again, that varies depending upon where you work, and that's not a set in stone across the board. That's dependent upon the business, but you are entitled to 30 minutes of uninterrupted lunch for 5 hours of work. You're also entitled to two 10-minute paid breaks during your shift. And that's, an 8-hour day. You get two 10-minute breaks, which who doesn't like a break? Everybody should get some kind of break. I think for me personally, the federal government, they do two 15-minute breaks, and they allow you to take an hour for lunch, but the standard's 30 minutes, but you're allowed to have an hour. But again, you still have to work an 8-hour day. In California, they have what's called wage orders. Now, wage orders, there's 17 of them in California, but they're organized by industry, and then they're organized by occupation, unless the job is included in a certain industry and it's modified by exemptions. So again, I'm not a lawyer, but it's really important that you understand that there is guidance out there to help you understand where a lot of these wage orders come from. Now, some exemptions, or known as white collar exemptions, executives. Now, an executive has to earn 2 times the minimum wage. So in California, minimum wage being $10, an hour, they would need to earn more than $20 an hour to be exempted or considered the executive earning those exemptions, as well as administrative workers requiring special training, experience, or have certain knowledge. Additionally, as well as professional workers, um, required work in a learned or an artistic profession. So, like I said, there's a variation of certain positions that have different rules based on the industry that they're working in or the specialty that they're working in. So, for example, a doctor would be considered a professional, but not a nurse or a pharmacist. Who have their own set of rules for how their wages are computed. And again, I can attest for this because we've had nurses who not only earned regular rate, overtime rate, but also earned double time, where our doctors earned a flat rate no matter how many hours that they worked. They received basically a salary. So that is definitely something important to note, that it's not a one policy fits all. Just because you're a hospital employee, it goes down into the weeds of what positions specifically are entitled to what. Now, going on to California overtime. California, anything over 8 hours in a 24-hour period is considered overtime in California. As I mentioned, under FLSA, anything over 40 hours in a 7-day work week is considered overtime. But again, California has exceeded this standard and said if you work more than 8 hours in a 24-hour period, you are entitled to overtime. And anything that is 8 to 12 hours in that day, so 8 hours and 1 minute to 12 hours, is paid at the 1.5 times the normal wage or the overtime rate. And again, if you work over 12 hours, you're paid at the double time rate. So there are various levels of pay depending on the job that you're in. Again, as what I illustrated before, where a doctor who works 13 hours might get paid the exact same amount of money, but the nurse that is working with him not only receives regular pay, but receives overtime and double time as well. So hopefully I haven't started losing you into the minuteness of the different pays, but it is, as a HR professional, important to note and understand how this pay works in relation to each position that you have in your organization. So there are some things that employees can do that kind of go outside those bounds, and the four tens, as we call it, the 4 10-hour shifts, those are okay to work. But what you want to make sure is that you have like a secret ballot and you get a majority. 2/3 majority of the people need to agree to work those 4 10-hour shifts. So it isn't the boss coming out of the office going, from now on, everybody's working 4 10s and you're not getting paid overtime, because that's not legal. And then everybody would be entitled to 2 hours of overtime a day that they would have to pay out. So you really want to get a consensus of your workforce before you try to just mandate a 4 10-hour shifts and actually have a genuine need for it that everybody agrees to. Because overtime violations and pay violations in general can get expensive, but specifically overtime violations can be $50 an employee per pay period, which doesn't sound like much. In 2 weeks, I violated it once, I'm on the hook $50. But if you have 1,500 employees, and you just did this to your whole shop, you can see how quick these numbers can add up as fines. Now, in relationship to children, California has, defines minors as anyone that's under the 18 years of age. And specifically those that are between 6 and 15 years old, their work cannot interfere with school. And basically they also have to have, all minors have to have a work permit so that they're allowed to work, and the businesses that hire them need to understand. I know personally, my son, he got his first job. He wasn't allowed to exceed 20 hours in a week. His grades played a factor in it. He had to have a work permit. So while it gives a business an opportunity to keep people employed at a younger workforce, they also have to be cognizant to the fact that it does take time. Now, in regards to some current issues that are going on, is you have the wage equality, the California Fair Pay Act, as well as expanded enforcement powers for the Labor Commission. And then you have the underground economy. Not only what I've researched a little online, but as well as what we've discussed in Management 358, that this seems to be a big issue in California, this underground economy. Now, the California Fair Pay Act went into effect in January of this year, and it was to help sew up the gap between men and women, to ensure that there was equal pay for equal work, that there wasn't a gender disparity between the sexes. But what they said is that employers are now required to pay based off of substantially similar work. So, not necessarily has to be the person in the cubicle next to you, but the person across town or in a different city that is doing substantially um, similar work, that they should be paid a wage that is comparable to their counterparts as well. It also prohibits reprisal for disclosing pay. Previously, employers would tell you that, don't talk about your pay, don't tell Susie what you get paid, she's going to be upset. Now you're open to discuss your pay to help, put it out there and keep everything above board and make sure that everything is out in the open. I read an article from Mr. Silverstein from the California Employers Need to Comply with the New Fair Pay Act, from InsideCounsel.com. And one of the attorneys that consulted for this article, Anthony Uncidi, he's an attorney at Proskauer Rose. He made some suggestions that, I thought they were actually very good suggestions for HR professionals to ensure that they're in compliance with this Fair Pay Act, and help to be a little preemptive to ensure that you don't have pay issues down the road. And what he said was that, and I'm quoting him, is that employers should require supervisors and managers who make decisions about compensation to document the reasons employees are paid what they're paid. They should detail the skill required, the effort expended, the responsibility given, the seniority, the merit, quality, and quantity of work. I think those two statements are important. Just as an HR professional, when you do hire someone, you do want to lay out every single thing that justifies why they're being paid the wage they are, so that there isn't an impression that one is getting paid more than the other for the same or substantially similar work. So everything is above board. Mr. Uncidi also went on to explain that might want to consider adopting mandatory arbitration agreements for all employees, which include enforceable class and collective action waivers. You want to keep your business in your business as much as possible, and you definitely don't want to end up in the courts, as our instructor in the class, Mr. Cushing, kept saying that, you don't want to be an example in the textbook, because that is not how you want to paint your business, as one that didn't do the right thing and ended up paying millions because they couldn't apply a little bit of preventive maintenance. But Mr. NCD, he finally, not finally, but he finalizes with, you want to train your supervisors and managers about the nuances of the new law and make compliance a factor in evaluating those managerial personnel. I think that really does hit home, and it resonates with me, is that if you don't train the people in the laws that we currently have, or to understand what's going on with them, then it's difficult to understand how do you expect them to enforce certain things. You can't enforce it if you don't train them to do it. So it's important that you train everybody at every level, and not just train them or sign a piece of paper or click through a PowerPoint slide that they did it, but to really hold them accountable and responsible for non-compliance, to show that you as an organization do take these matters seriously, and hold your managers and supervisors in the highest regard, to do what they're supposed to do. So also what the Pay Act did was it expanded the enforcement powers of the Labor Commission. So it allowed the Labor Commission, where they can file a lien on real estate that an employer owns, until they are in compliance. So if you've ever owned a house and had some work done, normally the contractor puts a lien against your house, and if you don't pay them, you can't sell your house. You're stuck. It won't clear title. Same thing in this situation, where you will have lien on the real estate, or they can impose a stop order on the employer's business as well. It also gave them some additional powers to where they can hold individuals that are acting on the employer's behalf accountable and liable, to make them do what they're supposed to do. If you're an employer and you hire someone to handle these matters, um, you want the person that you hired to be liable, because otherwise the excuse of, well, I didn't know, or I'm not the employer, and they get out of it scot-free, while you as an employer who entrusted them, are held solely liable. So it is important that individuals acting on an employer's behalf are also held accountable to a standard. The courts or the Labor Commission can also impose a bond to require the employees up to $150,000. For those that decide they're not going to pay the judgment, they might require them to have a bond, showing that they have that money. And again, it's just something else adding teeth to the fact that this law or the act is really serious about ensuring the gender gap, that it's eliminated, and there is fair pay for fair work. Now, the underground economy, there's a big paragraph that I put there on the slide that you can read, but basically defines an underground economy as one that is operating outside the norms. They're not paying taxes, they're not following guidance, they're not being regulated. And sometimes as an employee, you might not know that to be the case, but financially it could cost you, if the employer hasn't been taking out taxes or certain things, and you're trying to file your taxes to realize you haven't had any taken out, because they're not doing it. So there's a lot of tax fraud involved in the underground economy. A lot of, I'm going to pay you under the table, so to speak, or cash pay. And they're keeping things off the books. They're hiding the labor force that they have, from Uncle Sam or the California state or government, because they just don't want to pay for the taxes. Now, as an employee, you might like being paid with cash or under the table, so you don't have to report those wages, but eventually it ends up hurting you, because one, it gives an unfair competitive advantage to another type of business that's doing the things they should. So all goods and services could end up increasing, due to this underground economy. And California, again, has taken this serious, to root this out and help mitigate it the best they can by creating a joint enforcement strike force, an employment enforcement task force, and a labor enforcement task force that all have their own means of making sure that businesses are doing what they should be doing, and they're not cooking the books, just to avoid paying taxes, because ultimately it ends up hurting the employee or the worker. So now on the horizon, as there's been a lot of news and articles and TV broadcasts out there that California is signed into law that there will be a $15 an hour minimum wage. And I think it's important to note, because a lot of other people are starting to jump on board. In 2016 it went to $10 an hour, and now there's going to be an annual increase to $15 an hour by 2022. Now, the small businesses, if they have under 25 employees, they get a little bit extra time to implement this. So I am curious to see how that is going to pan out, because if you are in a small business, and you can find similar work somewhere else that's going to pay you $5 an hour more or $12 or whatever the case might be, that you can increase your income. I think small businesses are going to end up having to go along the same schedule in order to remain competitive and keep the employees that they have. Because $1 an hour might not seem like much, but when you're looking over a 40-hour work week, that's $40 a week, $160 a month. That's a couple of $1,000s a year. Why the businesses say they can't afford it, I don't know if they can afford to keep losing their employees. So it will be interesting to see if small business will actually keep pace with these increases, or if they will use this exemption the Governor Brown's provided. So, in summary, I've provided a lot of information. As you can see, the California wage laws are very diverse. They have a lot of information, but I hope I gave you a little bit of background. We discussed a little bit of the Fair Labor Standards Act, where it came from, where it's at today. California and their relationship with FLSA as far as exceeding the standards and trying to pave that way. And then some of the current issues that have been going on in California, and those that are going to continue to go on. That'll be interesting to watch as the years develop.